To carefully monitor the coffee break. Um, so our next panel is going to be moderated by Hanna Buxbaum, who has the honor of being a real choice of law person rather than who knows bankruptcy, as opposed to a bankruptcy person who makes up views about choice of, that's just me, law. We also have we have three participants here. Hanna will introduce them. We have a fourth who hopefully is, can we turn on Jay?
He turned on already.
No.
Wait.
Jay. All right. And
Hi, Jay.
With that, I'll hand it over to Hanna.
Okay, thanks. So at dinner last night, which means in Jay's absence, we decided on how this panel would work, which is two 15-minute presentations by Leif and Chuck, and then two 10-minute comments by Christoph and Jay, and then open for discussion. So I hope Jay is on board with that. So let's start with Leif.
Okay. So I'm going to see if I can do this from here. I'd like to start out by saying that I feel very, very honored to be in the presence of so many brilliant people. I'm surprised that you invited me to your party, but thank you. In all events, it is a delight to be here. My presentation has to do with the suggestion that modified universalism, which has been the touchstone for cross-border insolvency processes thus far for the last 20 years, and which has given us some extraordinary gifts in terms of cross-border mechanisms, most significantly the model law on cross-border insolvency. Also may have something to tell us about the rest of the story. As insolvency law has matured, it seems that we have discovered some new challenges, but we've also found ways to overcome those challenges. We've learned how to do the realization side in a remarkably coordinated fashion, despite extraordinary obstacles in some cases. And we've done it employing a variety of tools that are suggested by modified universalism. Cooperation, a notion that there is generally one proceeding which is more or less the main proceeding. Sometimes there's agreement on that, sometimes there is not, but there tends to be a sort of a de facto settling on what is the main proceeding, and that just seems to happen in cases. And we've learned how to manage the distribution, the realization side of the equation, sometimes with spectacular results. It seems to me that where we stumble is on the distribution side. The model law doesn't deal with the distribution side of the equation, it seems to me, and the distribution side has always been one of those sorts of things that, perhaps consistent with how we do insolvency law in general, at least with what I'm familiar with as a former bankruptcy judge, is that tends to get delayed until later. First we'll figure out all the stuff, and then after we've figured out all the stuff, then we'll figure out who gets the money. And we sort out who gets the money at the end. But it's the who gets the money part that can sometimes be especially challenging. And it's especially challenging, it seems to me, not only in a cross-border case, but in what is, I think, the de facto cross-border case most of the time these days, and that is a cross-border enterprise group. If there's a case of any size, it's not just one company. It's a group of companies. Some of them may be in, all of them may be in, but it's a group. And that is the de facto real problem that we face. It's a challenge, and it's one that it seems to me needs to be met. I'd like to start with by reminding us of what I think are some well-accepted principles. The first principle is that insolvency law of necessity interferes with non-bankruptcy entitlements. We forget this. The point has been made that insolvency law, no matter how much we may call it a procedural system, is de facto a substantive system. It substantially interferes with creditor rights. And it interferes with contractual rights, which are curtailed, modified, interrupted. Litigation rights are modified. Sometimes we find parties who discover that they thought they were going to try a case in one country, they're going to be trying it in another. They thought they were going to be trying a case with a jury, they're not. They thought they were going to be trying it in a civil court, they're going to find themselves in an insolvency court instead. What a surprise. And yet we don't think twice about that. But those are pretty significant interference aspects of insolvency law. Special claims might be elevated, or special claims might be subordinated. And again, we don't really give that much of a thought. That's just something that insolvency law does. We also see this in the way assets are administered. We see this in the sale of assets. We sell assets free and clear of liens, claims, and encumbrances in the United States. And in the United States, we don't even give that a second thought. It seems to be, well, standard process. And increasingly, similar kinds of sales are being done in other countries. It's been noted before that there is a confluence of insolvency laws around the world, and that means that we'll see more of what we see in one country in another country as well. We see this in plans. We see this in executory contracts. Executory contracts, it seems to me, is one of the places where it happens most significantly. But we also see it in plans where dissenting creditors can be bound by the will of the majority. Once again, we go, well, what's unusual about that? We've been doing that for at least 100 years. But think about that. From the point of view of the dissenting creditor, that means that that dissenting creditor's rights have been significantly altered by someone else with the cooperation of a court. And we don't give it a second thought. From nation state to nation state, we find some variations in these basic senses of how much we can interfere with creditors' rights using our insolvency regimes. But increasingly, as we've discussed this morning, national laws are harmonizing worldwide as nations reach consensus on the essential elements of insolvency. I've had the privilege of working with the World Bank in the last couple of months, and I have seen that firsthand. And it is an extraordinary development to see the extent to which nations around the world build their insolvency laws around things like the Legislative Guide on Insolvency, which UNCITRAL has promulgated. In the cross-border context, we made great progress in the 1990s. We departed from a territorialist, it can't be done, and we began to embrace a universalist ideal of why not? Albeit one that was accommodated to local needs, and of course that's why we call it modified universalism. There is a built-in tension. I recognize that tension. That tension is there and it always will be there. The fact that there is a tension does not mean that we cannot make changes. It simply means that we recognize that there is a tension. We understood that an enterprise, and under the model law that meant simply a single company, could achieve best realization of its assets by coordinating things in a single proceeding. And the model law gave us COMI. It gave us ancillary proceedings. Meanwhile, the world has moved on. And this is, it seems to me, the thing that so often we as lawyers sometimes forget. We build our legal regimes against precedents, against what we learned in law school about what we know about how law works. Meanwhile, business moves on. Business could care less what we do. They come to us because they have to. They write their things because we tell them they have to do them this way. And then they paper their things because that's what we tell them they have to do. They do it for tax reasons. They do it for labor law reasons. They do it for local regulation reasons. They do it for a whole variety of reasons. But businesses increasingly, I submit, are less and less enamored of the traditional notions that we have about how enterprise groups function. We have enterprise groups today that operate with a whole complex of companies, 10, 15, 20, 30, 40, 50 different companies. Are all of these companies really set up to be debtor-creditor oriented? Is that what their reason for being is? Or are some of them set up simply because you silo this enterprise here because that's the function that it performs? You silo this enterprise here because that's where you hold a particular asset. You silo this asset here for whatever reason. Increasingly, we're seeing greater and greater fluidity in the way businesses operate. And I don't think that the law has kept up with business, except it really has. It has because we've seen in insolvency cases again and again and again, certainly in the domestic context in the United States, de facto recognition of the fact that companies, enterprise groups, are fluid. In fact, they are so fluid that when you come into insolvency and then try to engage in the disaggregation game, where all of a sudden you try to pull everything apart and determine who owns what and who owes what to who, it becomes increasingly difficult to do that. And many is the case where the practical lawyers have said, I give up. It's not worth the candle. And so they come up with what amount to de facto substantive consolidations at some level. They may do them on a procedural basis. They may do them on a partial basis. They may do them on a complete basis. Sometimes they run into trouble. A lot of times they don't. And a lot of times the reason that they don't is because all of the stakeholders recognize that as a practical matter, this is the most sensible resolution of this insolvency process of this group. Because at a practical level, there is but one debtor. It may be broken up into a variety of different companies, but there is but one debtor. And there is but one group of creditors. Now, that's a fairly radical concept, I understand. But it seems to me that at least at the insolvency level, it may make sense to look at that a little bit more closely. Here's why. At the insolvency level, we take the enterprise that was operating outside of insolvency and operating through its various different entities in its various different ways, and we stop everything. Maybe we continue the business, but legally we stop everything. We stop everything and we say, okay, full stop. Now it's time to decide what are we going to do to get everybody paid. And we start asking very practical questions about how we do that. And when we start to ask those practical questions, we tend to ask them about the group. It's no surprise that it seems to me that very, very quickly in many, many, many insolvency cases in the United States, you will find enterprises which are, amazingly enough, bringing preference actions in which they say the debtor, and then they bring their preference action. What's going on here? The assumption is that the debtor is one entity, even though it may be 20. And sometimes smart debtor creditor lawyers will come back on the other side and say, well, this is a problem. But the point to be recognized here is that there is an appreciation of the fact that the enterprise is, in fact, holistic enterprise, and that in insolvency it may make more sense to talk about it as a holistic enterprise. Now, it seems to me that I need to finish up here because we're coming along here. It seems to me that practical outcomes that have been achieved in a domestic level can be achieved on the international stage, and perhaps even more importantly, because at the international level, we end up with some really incredibly practical, incredibly difficult problems. Now we have the choice of law overlay on top of the traditional questions about who owes what to who. And now we have the incredibly expensive process, and there have been some dramatic examples of this, the incredibly expensive process of trying to recreate what perhaps may never have been. And that's the important concept here. So what do I suggest here? I suggest that a modest change. I suggest that in the cross-border enterprise group context, it would be a modest adjustment to say, why don't we start with the proposition that it's one enterprise? If you can show me how you expected, how you anticipated something different, show me. And if the enterprise was truly operated in the kind of separated aspect that so many companies say companies are operated as, it's easy. You'll have no problem showing it. But if it's not, you'll have a devil of a time showing it. And that's the right result. That's the right result. Because at the end of the day, unsecured claims essentially are not that different across the world. An unsecured claim is an unsecured claim is an unsecured claim. I'm owed X money by this enterprise. And if I've gathered up all the assets, especially if I've gathered up all the assets, and sold them as a group, and now I have them in a big pot, to split them up now, it seems to me that that's a horrible waste of time. And that's a horrible waste of money. It's money that's coming out of the pockets of the very creditors that are trying to get paid. It seems to me that it makes more sense to say that the default rule should be Let's just put it together. And I suggest that those who say, well, subcon is something that you only use for wrongdoing, I suggest that that's not true. The facts on the ground say that that's not true. Thank you. The facts on the ground show, in fact, Bill Wyden has done a study which he published in the ABI Law Review in 2006, in which he tracked many, many subcon cases. These cases did not involve fraud. I don't even know that an affirmative showing was made that there was such intertwined activity that you couldn't disaggregate. Maybe there was. I don't know. But my point is that given the way companies today, enterprise groups today are functioning, it may be more practical to start with the assumption that they're one, and then ask someone who wants to show otherwise to come forward and show it. That may be a more practical solution. That way, one creditor gets one claim, and one creditor, as an unsecured creditor, has a claim against the entire assets of the estate. If you can show that you have specific expectation rights that would be adversely affected, so be it. You should be able to make that showing and should be able to do it with relatively little difficulty. Otherwise, it seems to me that that ends up with a prompt and efficient administration of the case that works to everybody's benefit. And it strikes me that with that kind of a rule, cross-border insolvency cases may be a little bit easier. Thank you.
Thanks. Chuck?
Thank you. Well, a couple of things. 3 years, less 4 days from today, Jay and I were sitting in a room in Tokyo when the mother of all earthquakes hit. We lived through it, so I hope you're okay, Jay. Also, if you think Judge Clark has crazy ideas, you haven't seen anything yet. So. I have no idea what my, that's the only slide I'm going to use, I think. I changed my mind. I have no idea what I'm going to write about.
Going off script?
Except it has perhaps one theme, and I'll contrast that theme with what we might say is the theme of this program, which is how can we make territorialism more entrenched and more efficient? One way is an undertaking, just ensure. So I'm imagining a harmonized choice of law project where many states would have the same choice of law. And I'm imagining one where in a secondary proceeding, a non-main, in an ancillary proceeding like under the model law, or just an ancillary proceeding where there's no establishment but some assets. The baseline choice of law rule would be to look to the law of the coming of the main proceeding. You know, many, many years ago, in the first restatement of conflicts, the idea was to imagine a cause of action, and we can call our cause of action a bankruptcy case, and to say one law needs to apply to every aspect. But that fell away to an issue-by-issue analysis, where we look to say, what is the appropriate law to apply to a particular issue? So my thought experiment, wish, would be that through the work at UNCITRAL and elsewhere, we could go through the major issues that arise in an insolvency proceeding and ask the question, is this appropriate for a non-COMI jurisdiction to adopt a choice of law rule that would look to the law of the COMI? Ted's forum shopping. I've always sort of liked forum shopping myself. I like all kinds of shopping, actually. But
My wife, too.
if you had such a law, if the strong default rule were the law of the COMI in a jurisdiction other than the COMI, there's less incentive to open secondaries. There's less incentive to place assets in places where you think they would receive favorable treatment. And when I think about the forum shopping for the COMI, which I think we also could take seriously, I don't see many jurisdictions saying, we want this law for a secondary proceeding, but we have another insolvency law that applies to main proceedings, because whatever a state picks is generally going to apply to all the proceedings. So for that reason, I would argue that forum shopping would be reduced and we could have a more efficient approach by greater deference to the Comey. Just a few concerns about comments that Judge Clark made in John Pato's paper on reliance. I think as we work through an issue-by-issue basis, looking at reliance or presumed reliance, as John talks about, might be one of the normative methodologies we could use in assessing an issue-by-issue analysis. What should be governed by the law of the Comey? What is an appropriate local interest? My trouble with reliance is that if it's not strictly presumed based on one's view of an issue, if you look at the entities involved, then you would have two players entering into identical transactions with the same debtor, but they would be treated differently because of their subjective intentions. And I don't know what the subjective intention of Lehman Brothers Europe is, International Europe, or the subjective intention of Lehman Brothers Holdings is. I don't know how we assess that. I don't know about the corporate group aspect of this. My mind is completely open. But if my client's going to do a $100 million overnight repo with a given entity, I wouldn't like the idea of presuming substantive consolidation. Wouldn't be a real boon to the securitization industry, I would think. So my goal is to open this up, and if I've got any time left, to ask for some comments.
You have lots of time left.
Do you want comments now? Or now, for the rest, and then we can open it up later, too.
I have.
Oh, we should, yeah. Let's move that one over.
As you can see, I like asking questions. First of all, I think it's helpful to understand what you mean by an issue-by-issue approach, because the thrust of your comments is you think we will conclude, going issue by issue, that ultimately we should allow the Comey's law to apply to most issues. And that having been said, what are the criteria that we use, if not reliance, for making that determination?
I think a multiplicity of criteria, like we would on any difficult policy judgment. There's room for reliance. There's room for what people will argue the equities. There's room for economic analysis. And by the way, I'm not a universalist, and I'm not a territorialist. I'm sort of a questionist. And I think this exercise would be useful. Issues, for example, the standards for assuming or rejecting executory contracts, to use U.S. bankruptcy language, ranking of priorities of unsecured creditors, those kinds of issues. But I don't have a magic wand. I suspect that when we go through this issue-by-issue basis in a consensus-building environment like UNCITRAL, we're going to say, wow, this is really a territorialist world. And if everybody can just shrug their shoulders and agree to that, then we can use our time more productively. Because I don't think it's got us very, very far. That's not to say that the model law and the cooperation that comes out of that has done a really great thing, but as you say, it's ad hoc. And in the U.S., the standard seems to be, when we look at some of the case law and our non-uniform Article 7, the outcome determinative factor in comedy is your law like mine? If it is, I'm happy to defer. If it's different, different, like as Will Rogers said in the 30s, when all those Okies went to California it raised the IQ of both states. Well, he was a little different, so I don't know if that's responsive, Don. John?
So I actually, I think your proposal is actually quite attractive because I have to think some more about it. I think you can remain agnostic as between universalism and territorialism and just say, I would love to have it's sort of like I don't know what the reverse of a renvoi is. It's a de-raw, and saying, I just want to have everyone's private international law be the private international law of the COMI in a proceeding. What worries me is that I think to get to that sort of mindset where there would be buy-in for that, it is basically universalist. It does require the subjugation of your law to the forum state's law. So I hate to say it, I think you have to be dragged in, perhaps involuntarily, to the universalist fold, which is fine. And what might be, if we sort of now wear our modified universalist hats, like our little pragmatic, taking Gabe's admonition is, that might be a discrete enough proposal that it could actually get some buy-in. I just don't know, and I would defer to Jenny and Chris and the guys who know how the system works better than I do.
As long as we keep in mind that words like modified and constructive mean not.
Well, part of this. Listen, part of this is like fig leaves and stuff, and you can't. It's like jury nullification. You can't be too bald and on record about it, then the whole thing falls apart. And one little thing with reliance, you can use reliance because you can just say it's an objective standard. You don't have reliance does not require subjectivity. You can say a reasonable reliance of what.
Well, I guess what I was going to, whatever the standard of reliance, if one party relies on the law of the COMI or the law of the non-COMI, and another party doesn't, but they have identical transactions, you would be treating them to two different regimes.
Well, sure, but that's an evil with any, right? In territorialism, if you have two guys with assets in different cases.
I think it's just evil.
Can I, since Chuck has ceded some of his time, I'm totally going to abuse the prerogative of being moderator here to say something myself. And I do this with some trepidation because it may be exactly the kind of academic comment that Gabriel warned us against in the last hour, but I'm doing it anyway. I think it might be important to keep at the surface the difference between conflict of laws and choice of law. So international insolvency manifestly presents conflict of laws difficulties in all kinds of ways. But choice of law is a much narrower project, right? What we mean there is that the forum court is actually going to select the law that it will then go on to apply to the issue in question. And, a lot of what we're talking about, certainly when we're talking about secondary proceedings, is not choice of law. It's talking about, will we decide to defer to the court in the COMI state or by, let's say, relinquishing assets or not. That's not choice of law. I think the analysis is animated by choice of law values, but it's not strictly speaking a choice of law. And when you're talking about formal, narrow choice of law, it typically does not work when you're speaking of mandatory law. This is why the law of the forum in areas of public mandatory law will always apply its own law, because it does not have the freedom, if you will, to displace the public interests articulated in that law of its state with the law of some other jurisdiction. And so I think, this might be another useful dichotomy to keep in mind. It's not really a substance procedure dichotomy. It's mandatory versus non-mandatory, right? So, as Leif said, insolvency law disrupts, many other entitlements. Well, some of those are private law entitlements, like contractual entitlements, but some of them are public law entitlements. And I think that's where international insolvency runs into the greatest problems, is when the law of the COMI state is seeking to disrupt a public law entitlement in some other jurisdiction. And so in addition to, like presumed reliance and other factors that we could use to distinguish, let's say, the hard cases from the easy cases, I think some attention to this public-private which is ridiculous to say in 2014 because we're supposed to be beyond public-private distinctions, but there it is.
A couple of comments on that. One is, of course, a choice of law rule has to defer to the basic public policy because that underlies everything. But you can take a conflicts of laws and make it a choice of law, like in the global rules, and say, if you open a secondary proceeding, the insolvency law of the non-main jurisdiction applies to all of these things except 1, 2, 3.
Yeah. I totally agree. And I actually, in my view, and I am kind of a universalist, I think it has to be in a formal legislated choice of law regime for this to work. And I think that should happen.
There's two issues I think are relevant. One is I don't think you can assume a clear determination of what entity where the COMI is. That's been a much litigated issue in many jurisdictions. In many situations, companies try to strive because of specific lenders to establish COMI. I've seen COMI documents where the loan agreements say COMI is in this jurisdiction to this lender, and you have 5 lenders, and COMI is everywhere else. The second issue is that one of the discussions we had, both the colloquium and the working group recently in Vienna, was the fact when you look at a group enterprise issue, one of the considerations is you may want to determine that you don't address COMI. You don't look because the group enterprise has so many different locations, has so many different components. You may get away from the group enterprise, the COMI issue because of a jurisdictional issue, among other things, about how do you, if you have a number of companies that are diverse in different jurisdictions, how can you establish a quote a COMI for the group as part of the process? And so I'm making those comments because a lot of the comments you're making say once you decide COMI, then a lot of this gets incorporated in the process, and so that's a predicate that is a difficult issue that has to be addressed also.
So we're now out of Chuck's time.
Thank you, Chuck.
So
You're very welcome. Quite welcome.
So let me turn to Christoph.
I wanted to go there, but I don't, for a reason which I will explain in a moment. Because I'm starting with two preliminary remarks. The second one was supposed to be very short, but now it's consuming the entire time of my time slot. Nevertheless, let me begin with thanking the Brooklyn people for inviting me again here back home. I feel really like being here. At home, second home, my wife said, well, here we are living. And did you get the message? Second remark is, thank you very much. Second remark, I was prepared. I was reading the papers of these two guys whose papers I was supposed to comment. And I read both of them, of course. They both changed it. He changed it not dramatically, but he changed his paper dramatically. And he did it. He did. And he rewrote his paper by writing what I wanted to say. So for that reason, thank you very much. Thank you very much for your attention. Any questions? We can continue. Nevertheless, let me try to summarize what he put in much nicer words than I did. And to pick up your comment, Hanna, I'm now speaking, after all, this is, Jay, you will forgive me, it's a US-dominated panel, and I'm the fig leaf here, I'm the European fig leaf, but the reason I'm taking the European perspective, I'm talking about private international law. That includes both of your distinctions, and for that reason, let me take this position. And I wanted to start with the question or with the issue, which was raised for the first time this morning, and then several times afterwards it was repeated by Jenny, that choice of private international is highly complicated and makes things extremely intricate and complicated. Whenever I'm confronted with complicated issues or matters of complication, I'm stepping back and pulling on my position as a legal historian, and I'm trying to find out what is it all about. I'm trying to simplify the things. And then I'm looking at the private international law, in this case the choice of law, and I'm asking what is it good for? And then came Chuck and just said, of course, we are trying to find the most appropriate law. What is for certain issues in law, the most appropriate law? And raising this fundamental question makes us ask the question in the context of insolvency law: is insolvency law of a particular national jurisdiction important enough to wipe out more or less all the other existing legal positions that creditors or stakeholders might have under different laws? This is the thing which I find a little bit too simple with your life's proposal. You are just with this substantive consolidation. You are really just saying, here we are, we have one enterprise, and this is governing the entire thing. That is probably a bit too simple. But nevertheless, I just said to him that in Untitled we came up with the proposal of extending the idea of substantive consolidation, and it was the U.S. delegation, Chris and Leif, who came to me. We can't do that. Insofar, I was extremely pleased by the first presentation. I was disappointed by the second.
To quote Abraham Lincoln, this morning I was wrong.
All right, Abraham. Now, what I wanted actually to do with the remaining couple of minutes is to look at the most extensive list of description of what constitutes the lex concursus. And by now you know what the lex concursus is, the law that is applicable in the main proceeding. And that is Article 4 of the European Reg. And it has an extensive list of what is part of the lex concursus. And what is interesting in this context is that there are 10 exceptions to this list, which you find in the Articles 5 through 15. And they are saying that we apply the lex concursus, but we have modifications. And it's usually said for the reason of reliance, which is a concept. Even though you might call it reasonable reliance, there is always something what I call in German, and I've written on that, a psychologism. It is something, no matter how objective you want to describe it, there is a lot of sentiment behind it. And this brings me incidentally to your question, Don, which you raised before, and which makes me afraid to a certain degree, because that is what I heard out of your question when you were raising this American judge who's coming up with a de novo examination of something which under the written law should have been acknowledged without further ado. That is my fear. We are talking here about extremely important things, and there's no need to stress this importance among us because we are kind of experts. Namely that we develop rules which are pushing forward the things as they are, but we might be in the dangerous zone that we are extending globalization to an extent where the individual judge, the deciders, are not following us. And I'm afraid, and now I'm talking not just as a European, but primarily as a European, we are drifting into a time where territorialism gains some ground. What I find dangerously much ground, but we find it all over the world. There is a counter movement of that, well, this globalized thinking is fine, and it might be to the better good of the entire group of the stakeholders, creditors of a particular group or enterprise or a group of entities. But it might be that we don't reach the understanding of these people anymore on the street. And under these circumstances, the concept of exceptions to a general rule of universal applicability is getting more and more important. And under these circumstances, I wouldn't talk about, I would hesitate to talk about reliance. I would call it more openly. It is a balancing of political will. After all, we are in a political sphere here at this point of time. And just to give you a few examples, we have this exception in Article 5 that the rights in rem are exempted from the general rules of the lex concursus. This is, as we know by now, abused by the powerful creditors for creating harbors, safe harbors, for their security interests. This is something which, in my mind, is at least disputable or discussable, should be discussed, that it should be reduced. We have also in Article, 2 more minutes, wonderful. I thought I was over already. We have exactly. You learned the lesson. We have Article 9, which gives an incredible exception to credit institutions. And this is something which almost to certain contracts of the credit institutions, important contracts, and that this is nowadays an automatism almost all over the world, that in every insolvency law you have these exceptions. The lobby work of these guys was efficient. We internalize all these exceptions from the general rule of par conditio creditorum, from the equal treatment of the creditors, which under European understanding is the baseline of all insolvency law. On the other hand, we have something like Article 10, where we have a distinction which you didn't have in your first paper, incidentally, in order to pick this up. We have the distinction for workers that the general law of work conditions is governed by the lex laboris, the law which is governing the labor law. But the ranking is a question of the lex concursus. So we make this distinction. And having this rule, for instance, in the Nortel case, which you addressed in your paper, you see, I've read it, this exemption was good enough to prevent the German Nortel case to file for a petition of a secondary proceeding, because the protection granted through this exception was good enough to give the laborers all the rights they wanted to have. They could live with the ranking situation under the English law, because the main proceeding was in England. So insofar, all what I'm trying to say, and thereby I end, is we have, that is my understanding and my proposal, we have to very carefully look at a general rule that is easily established, and then to look extremely carefully to the exceptions that we want to establish, for which reasons, and to rethink the necessity of that. And reliance is only one of the possible arguments in this context. Thank you very much.
Jay, the floor is yours.
Well, thank you. Are you actually hearing me?
Yes.
Oh, good. I have to start by saying Ted Janger's conference, of all people, concerning choice of law in international insolvency, of all subjects, at Brooklyn Law School, of all places for that subject, where so many wonderful international insolvency conferences have taken place, and all of you, whom I have known and admired for many years, and I am not there. It is almost unbearable, and only the wedding of a very dear friend keeps me from being with you. I want to thank Ted for permitting me to be here virtually. I appreciate all of that trouble and effort very, very much. I, too, am supposed to comment on Chuck and Leif's papers. I must say the papers in the conference as a whole are wonderful, and I wish I could speak with each of you about them. And obviously, in a short time, I can only speak really in generality, so forgive me for that. Leif's paper is terrific. My problem is I can't critique it very well because I agree with it almost word for word, so I could simply say he nailed it and move on. But I want to say a couple things. I want to highlight a couple things about his paper. he brings forth the first and most central point about choice of law in international insolvency, as far as I'm concerned. Choice of law and choice of forum have to be considered together. John, thank you for your footnote. They must be understood separately, but not independently. That is, they are two distinct variables with distinct functions, yet they interact intimately, and neither can be understood except as part of that interaction. All of that may seem obvious to many of you, but it seems to me it frequently escapes us in the way we think about choice of law issues. Among the many implications of this principle are that there are crucial differences between an ancillary type of proceeding and a full bankruptcy under local law, and equally crucial differences between a secondary proceeding, that is to say a non-main proceeding, and a main one. Beyond resting on that foundation, a very solid foundation, Leif's paper has an insight that I think is important, and that is the interaction between the group insolvency question, that is, do we treat an enterprise group as one, or to what extent are we prepared to disaggregate and look at each corporation separately? That there's a close connection between territorialism on the one hand and this question of enterprise group or not on the other. Treating the various members of a corporate group separately certainly may be necessary and proper sometimes, as Eric points out, but treating them separately is a very strong boost to territorialism. Indeed, it tends to make universalism very hard to achieve. And that relationship, it seems to me, has not been talked or written about nearly enough. Chuck's paper is enormously helpful. Chuck, I really liked working through those examples. I thought that was a great idea and a very helpful one. I can't address those individually, of course, but speaking more generally, one thing that's important about Chuck's approach is that he sees the relationship between choice of law and choice of forum in the specific context of cooperation. I think the choice of law question is very different depending on whether or not you have courts that are cooperating as contemplated by the model law or by other statutes in other jurisdictions or not. And I don't think you can consider what makes sense in terms of choice of law in isolation from knowing whether or not there's going to be effective cooperation. Of course, you can turn that on its head and say the more we have good choice of law and common choice of law rules, the more likely we are to get cooperation. In addition, Chuck talked a lot, especially in his original paper, about avoidance law. And I think it's worth saying that if you had to pick out one single choice of law issue that may make more practical difference, both in litigation and maybe even more so in transactional question, it is avoidance law. It's enormously important, as Maxwell demonstrated dramatically so long ago, which choice of law rule you might apply to avoidance. And one thing that's important too is to see this, I think. An avoidance action is, of course, a cause of action, like an action for breach of contract or for a tort, for example. That's one of the few things that Lord Collins got right in the Rubin case, for example. But on the other hand, it is very different from those causes of action insofar it is one piece in a very large machinery of financial adjustment in the context of financial distress. And therefore, it can't be treated as an independent question. It is intimately tied up with the proceeding that is going on in the cases we're talking about on a global basis. I think it's important to point out as well that avoidance actions can be brought in either an ancillary proceeding or a full bankruptcy. In either case, as far as I'm concerned, a foreign avoidance law can be applied, as well as a domestic law. And this is, of course, in an ancillary proceeding context, illustrated by N. Ray Condor in the Fifth Circuit in the United States, where foreign avoidance law is made available to a Chapter 15 foreign representative. It's much easier to do that and to understand how to do that in the context of an ancillary proceeding than it is in a full bankruptcy. what I think is an underlying principle that we don't discuss very much in connection with avoidance law, and it kind of gets lost in the conflict of law discussion, is the intimate connection between avoidance law and distribution rules. That is to say, choice of avoidance law should be closely connected with our choice of distribution law. Call it priorities, if you will. Why? Because the whole point of avoidance law is that we're going to take that recovery and redistribute it, with apologies to Senator McCain, we're going to redistribute that recovery to those whom the legislation in the relevant country, of course that's our question today, what country is relevant, but in the relevant country, in order to rebalance the recoveries of creditors. That's why we have avoidance law. All right, there's the odd case of actual fraud, but far more often we're dealing with questions of redistribution in order to, of recovery in order to permit redistribution. And I think all too rarely do we talk about the connections between distribution on the one hand and avoidance law on the other. I would love to just get back into a general conversation here. I don't know if I can participate effectively from, what shall I say, up here, but I'd like to. But I want to close with one other thought, if I may. You guys in the first panel didn't know you were under surveillance, but I watched a good part of the first panel, which I enjoyed very much. And I want to respond or react to Don Bernstein's question, which I thought was a very good one, and perhaps to some extent to Chris Redmond as well. Yes, it's going to take a long time to get things through UNCITRAL, and then we have to get them through national parliaments and so forth. But first of all, there's the point that Leif made, which is incredibly important, and that is UNCITRAL has a much more immediate impact in many countries in the world than it's apt to have in many of the advanced countries, because those countries are working with the World Bank, they're working with the IMF. To some extent, they're under pressure, and to some extent, they simply want to develop modern commercial laws and be able to point to them as they seek to gather foreign investment. The cases are happening now. I think that was Don's point. This is an ongoing business. As Leif said, business isn't waiting for us to figure out how to do this. Business is pushing on. And I think it's really important that we push on as well. And in connection with that, forgive me for some of you who have heard this before, but when we sat down in Vienna in 1995, we were solemnly assured we didn't have a prayer of doing anything useful whatsoever. And I think most people looking back now would say, well, yeah, we did something over a couple of years that turned out to be at least helpful. So I think we have to reach, not that a man's reach exceed his grasp, but that we not be too modest about what our grasp is. And in that connection, I would remind you, what UNCITRAL does influences not only legislatures in the long run, but it influences practitioners and judges in the much shorter run. And therefore, I think its work has profound impact on a shorter time scale than we might always realize. Well, I probably have spoken too long. Thanks again for letting me be virtually here.
Okay. I think the floor is open for general discussion. Irene?
So one comment regarding reliance and the discussion between John and Charles Mooney. And the other comment is regarding substantive consolidation and what the model law does or doesn't do in this respect. Reliance, I think, does play a role in designing private international solutions, but it can't be the only factor, not only because it's relatively subjective, but also because it's a little bit circular, because we design a particular private international rule on jurisdiction, on choice of law, and then the expectation may follow. The other comment is with regard to what was said earlier. First of all, regarding the model law, the fact that it deals with realization but not with distribution. I slightly disagree with that. I think the model law does deal with both to some extent via the relief provisions. So via the relief provisions, you can, it's possible as a court, transfer the assets to the foreign proceedings for both realization and distribution purposes. What the model law doesn't do is deal with the choice of law question, and that's not specific to distribution. It's more general. It's which laws will apply in terms of the reorganization process, discharge, etc., etc. Now, in terms of substantive consolidation, I think it is. I agree with the universalist approach and the need to consider the link between groups and international insolvency. However, I do think that it's important to distinguish between the private international issues and the substantive issues, whether or not we consolidate the proceedings. One question is the private international law question, or specifically the choice of law applicable law question, and that is which forum and which law will apply to the question whether we consolidate the proceedings. This is one question. Another question is whether that law that will apply should or shouldn't allow consolidation, and it's important to distinguish between the two because different factors should apply in the two different cases. And now just a word about technicalities and back to the question, what is the working group is going to do in this respect, because we mentioned that we will discuss enterprise groups again, but it is important to note that in terms of the mandate, we are going to discuss the private international law issues related to groups, the cross-border insolvency of groups, developing the model law in this respect. It's not really about substantive consolidation because this is something that the working group already discussed in the context of the legislative guide, and the legislative guide itself, part 3, distinguishes between the private international aspects and the question of consolidation, and I think rightly so, and I think that the working group done a very good job in striking a very delicate and appropriate balance between the corporate form and economic reality in the context of the consolidation question.
I have Ted and then John and then Helen.
So I wanted to say 3 short things. One addressed to Jay. Let me grab this one. Yeah. One addressed to Jay, which is one of the things that I've always found or viewed this conversation about choice of law and expectations as being a conversation within universalism, and that we are, rather than a conversation about universalism versus territorialism. And the trick here is to figure out, and I think we all agree, that the question is at what point should bankruptcy be a trump, and at what point do territorial concerns become more appropriate and dominate? And that comes up whether we have a rule for it or not. It's just a pragmatic concern within the process. And in thinking about the scope of the question we're asking, right, I'd actually like to suggest narrowing it to a very narrow question, which is when should the main, in particular, but sometimes the secondary, be empowered to derogate from its own national bankruptcy law? In other words, when is a choice of law question appropriate? And then there's a second order question, which is what is the choice of law determination? But right now there is a live question as to whether any country other than the UK can honor an undertaking, right? And so whether that is something that should be in the toolkit of the coordinating jurisdiction or not. And that raises sort of a second question, which is where this gets phrased in terms of consolidation. And there are a couple of different ways of thinking about consolidation. There's substantive consolidation and there's administrative consolidation. And what Leif is describing, I think, is a presumption in favor of substantive consolidation. And what I think I'll be talking about later, others of us are talking in terms of a presumption in favor of administrative consolidation, which, by the way, in the U.S. refers to corporate form, but would in the international context carry with it and how do we work this in, a notion of territory. And then the question becomes, what are your presumptions? When do we pierce that form and under what circumstances? The thing that I think we're all struggling for is how do we calibrate that question in a way that facilitates coordinated central administration and governance of the case. I guess that was that. I don't know if that's a question or an observation, but that's sort of a series of questions, points.
John?
I have a somewhat, let me take this out. Craig. Okay. Hi. I have a somewhat middle child response because I want to, I don't like it when my parents are fighting. So I want to try to find a way to synthesize some of the differences between Chuck and Jay's and Life's approach. And it strikes me that it's a very simple point you made, but I think it's an important one, which is that the modern reality of corporate groups is probably far away from what they were envisioned some time ago when these instruments. I mean, there's just so many overlapping things that are done on paper for just tax reasons that have nothing to do with the traditional separate entity point of liability. That if we were to take an empirical approach, if you hooked people up to truthometers, they'd probably say it really is one big thing. Okay? And if that's empirically correct, then the presumption of starting with a consolidation approach, a substantive consolidation approach, is an attractive one to me. Then, Chuck says, but then you're going to kill securitization. And I take that seriously, right? That's a concern. So the question is, and I do this a bit in my paper, is can you have such presumptions that track empirical reality, but also allow an overlay of contractual choice without destroying the system? And that, to me, speaks to a collateral question, which is about the merits of forum selection and good forum shopping, which Chuck says. And I think those are synthesizable. I think you can have empirical presumptions based on Comey groups that do track reality, but also leave an avenue to respect forum choice, provided it's not abused. And so that would be the sort of my recommendation or framework to try to synthesize.
Yes.
Just want to respond to that. Clearly, you could carve out property-based claims so that sales and secure transactions could be carved out, but the question would remain if it's a secured debt, would you be consolidating that deficiency claim? And you could say, sure. Yeah. You could say everything's together, but if you've got a property claim, we're going to honor that.
Yeah.
Judge Crawford.
I can only speak for the poor common law judge. Who has to administer the law as it's written today. And most of whom are going to be confused somewhat by ideals of universalism versus territorialism. And I agree completely with Eric's comment that the statute as written today provides for administration of assets in another country by the administrator in the main proceeding and provides for distribution in the main proceeding, but also has those tricky words in the model law provided that creditors in the secondary jurisdiction are adequately protected, translated in the United States into sufficiently protected. Tell me what those words are supposed to mean. And in the United States, we are developing a body of laws under Chapter 15, and we are stuck with sufficiently protected. And I will develop this more in my particular paper presentation, but we can't blink the fact that the statute itself, as to use Christoph's term, has many territorial aspects to it. And we can't blink the fact that, as the Supreme Court again told us this week, bankruptcy judges have to apply the statute as it is written, period. Don't be imaginative. Don't go beyond the words of the statute. Once again, we are told, do what the statute tells you to do, even if it's idiotic. And we have those. I will say without any hesitation, we have those decisions, which I'm sure you have read. So I will save my comments until later, but I think that we are subsuming choice of law issues into concepts such as sufficient protection or adequate protection, into the question under 1507 in the United States as to how much alike does the foreign law have to be with our law. We would be much better if we introduced choice of law back into those questions, and we would probably encourage good judicial behavior, to use a term that Don used, or perhaps stated better, good decisions. But
I do think that in many of these cases they are choice of law or conflict of law decisions, would be better treated as such, but that we have to deal with the statute as it is written.
I believe Jay has an intervention to make.
If I may. And Judge Cropper's comments, I think, are very much to the point, and as well as his really excellent paper. But I'm surprised that he is so worried about sufficiently protected as opposed to embracing it. The nice thing about sufficiently protected is that I think even Justice Scalia would have to struggle to say the plain meaning of that is, fill in the blank. It gives judges like him an opportunity to create and develop the law in this area. For example, prior to Vitro, 8 consecutive, in a row, Mexican concursos had been approved in the United States and enforced, which means, in effect, we granted discharges in the United States to 8 reorganization plans developed in our neighbor to the south. That's fantastic. That's incredible progress. Then we reached a point where Judge King, in her eloquent and fascinating opinion, said, you know what? This one doesn't sufficiently protect predators, which of course seemed to me, since I was involved in the case, patently to be correct. But whether it's correct or not, that's what she saw, and that one doesn't get approved, and there is no discharge in the United States for that concurso. It seems to me that's a perfectly appropriate kind of development. Now, it's a real problem for our civil law friends to rely on those kinds of developments. But for those of us, at least in the common law jurisdictions, certainly in the United States where we have really good bankruptcy judges, I don't see any reason to be unhappy about that. I do think, once again, that this is an area where the more that comes out of Untitled, even if it's 20 years from now before it gets through the House of Representatives in the U.S., will influence greatly the laws that are developed in other countries around the world, particularly in emerging markets, which are increasingly important. And in any event, they will provide more grist for the judicial mill in the common law countries and more guidance to judges in reaching sound results.
Don?
Just to say that I totally agree with what you said and with your paper. I think this should be the next project of Ancestral Working Group 5, or part of the project, to fill in the gaps and those fluffy concepts in the model law like sufficient protection that are part of the choice of law / enforcement question that wasn't discussed, perhaps rightly so, because of this incremental approach. So definitely this is something to consider as a next step. How do we fill in these gaps in the model law?
Well, first of all, I too want to compliment all the panelists because, again, these papers are very, very illuminating, and also the comments especially. On the question of the open texture in the model law, I think everyone who was involved in that process thought that that was one of its best features. But it was on the presumption that we had a largely universalist judiciary that was going to be interpreting those words. And as I said before, I think what's happening is there is some attrition in terms of the universalist judiciary, which means that we are now facing problems that we thought were going to be overcome with the open texture of the law. On the issue of substantive consolidation, I understand what Jay is saying about it encouraging territorialism to have separate entities respected. On the other hand, I'm worried that we are letting the fear of the politics overcome common sense, because we have, in single country situations, multiple entities, and you can have a single law apply to all of them and still respect the entities. So what worries me is that we may be going too far to say that the presumption should, and as Leif would suggest, that the presumption should be that of substantive consolidation. And one question that we face all the time is the corporate group that has one bad company, the bad company goes bankrupt, its creditors get wiped out. Are we saying that there should be piercing the corporate veil in that situation? Because, in effect, the rule that would have applied had the whole group gone bankrupt would have been substantive consolidation. I think we're we have a world in which entities are meaningful, and we want them to be meaningful for credit and other purposes, and we can't throw that baby out with the bathwater.
Gabriel and then Ted.
I want to raise a bit of a troubling question, a sort of Wessels type question. We've rather, I think, tended to run together questions of choice of law in two rather different types of situation. One is what one might describe as a relatively closed system, like the EU regulation on insolvency proceedings, where to some extent you're treating the group of countries as a quasi-federal group in which there's shared sovereignty, and there shouldn't be, sometimes there is, but there shouldn't be that kind of annoyance about the interference from a foreign court or the powers of a foreign court, on the one hand, and then the pretty much completely open system, such as the UNCITRAL model law, where one's looking at effectively globalism intruding on local interests. And I just want to give us an example of the kind of issue. Christoph's Article 5 point, just to explain to those not familiar with it, Article 5 of the EU regulation says that if you have a main proceeding, and let's say that has a stay on enforcement of security interests, if you're, let's say, a bank and you have a security interest over an asset in another member state of the European Union, it only applies to other member states, other than where the main proceedings are taking place, then the main proceeding cannot stop you enforcing your security. Now, that's something which, as I say, only applies in a relatively closed system. And it already has its own antidote, in a sense, and that is that if you're going to have a valuable asset in security in another member state, there's a pretty good chance you will also have an establishment. If you have an establishment, then a creditor who doesn't like this safe harbor idea that Christoph mentioned, they should be able to request the opening of a secondary proceeding. And this is one of the few cases in which a secondary can really be justified in the interests of local and perhaps other creditors, and request the opening of a local secondary, which may well carry its own local stay of enforcement of the security or some kind of balancing of interests. And I think that's a very good example. You don't have that sort of provision in the model law, although if you read the UK version of the model law, actually we do, because we put it in. But that's a kind of working example of the possible difference between the two types of approaches.
I'm being slightly hypocritical because I signaled Hannah that we should ask questions to the audience, and then I took one myself. We talked about substantive consolidation, and I sort of wanted to offer a little bit of substantive consolidation lore that I think we sometimes forget, which is the classic substantive consolidation that we all teach in our bankruptcy classes case is a case called Augie Restivo, where a corporate group is consolidated, but what everyone always forgets is that at the distributional phase of Augie Restivo, the court said, well, some of these creditors dealt with the entities as sole creditors, and therefore we will vindicate that expectation at the distributional phase. And this sort of raises a question to me. Actually, you cited Bill Wyden's study about substantive consolidation, and I've asked Bill this question, and I've never gotten a good answer from him, which is he finds that all... No, I don't want you to give you. I'm going to flag the question. We need to figure out the answer, which is when he finds all of these cases substantively consolidating, that's fine for administrative purposes. What he never answers, and as far as I can tell hasn't looked at, is whether those substantive consolidations retain flat pari passu distribution or whether within the plan some of the old expectations are reconstituted. And so, which all brings me to the point that I think at some very basic level, we're agreeing with each other more than we think and just trying to figure out how to make this thing work. And that's all.
Responses from panelists, and then we will have some time for questions from the audience. So Christoph and then
Thank you.
Dave.
Thank you. Very brief question to Gabriel. Even though it's stupid when I'm responding that because you are the practitioner, I'm the academic, you know it better than I, that in contracts nowadays, the secured parties, they impose by means of a contract on the securing party that they must not create an establishment in this particular country. That is the new development.
They say that, but if in fact they do, then of course you can open secondaries anyway.
Thank you. Just to respond briefly to Ted's point, and I've heard a lot of things here that I agree with. I recognize that the position I laid out was provocative. I knew it would be, but sometimes the best way to state a principle is simply. And then you go back and you begin to tease at it and figure out where you need to make modifications and adjustments. I feel as though I think a basic truth has been stated there, albeit one that may need to be adjusted as we start to look at it more closely. But I think that there is something to be said for taking a hard second look at the concept of substantive consolidation in the international context. Because I think we have drafted the concept as though it was 20 years ago, or even 30 years ago. I mean, we have built on principles and concepts that go back to the 1980s. I mean, the Auto Train case and the Auger Vestivo case out of the United States, you can virtually read the holdings in those two cases in the standards that are there in net recommendation, 220, in the legislative guide. So in a sense, I think we may have some work to do at the international level, giving further refinement to what are the appropriate circumstances when a main proceeding might entertain at least the proposal of a substantive consolidation type solution. And I say substantive consolidation type solution because the term subcon has taken on such a pejorative, it seems to me, in much of the dialogue that you can't even mention the word without getting people's hackles raised, and that I think is inappropriate.
Any interventions from the audience? Yes.
To your point, I think that we lead ourselves a bit astray when we talk about substantive consolidation because it raises a lot of very difficult issues. I think about the Enron case. It wasn't substantive consolidation. What it was marshalling. I think you can have marshalling in an appropriate case without all of the difficulties that Don has raised in respect of the issue of substantive consolidation. I've never considered that, in any event, to be the determination of substantive consolidation. I've never considered really to be an equitable solution to wrongdoing. There are good substantive standards that people can apply to substantive consolidation. Are you intermingled? Are you really one company? Marshalling, I think, gets to the same objective, assuming consensus, that substantive consolidation does without raising those issues. So that's the point I'd like to make.
One issue I think we have to look in regard to is you can have horizontal and vertical entities. So, trying to establish an issue of one size fits all, I think becomes maybe oversimplistic as part of the process. The second issue is that when we discussed group enterprises at UNCITRAL, we had a very substantial, vigorous conversation in regard to substantive consolidation. And finally, after probably 4 or 5 sessions, we're finally able to agree on some language that was a moderation by many different states. And so part of the issue is you have to be realistic as part of the process. And the issue is, at least from my perspective, is the states don't like opening up issues that have been resolved, because especially when you go through a long process of having to reach a resolution. So I think part of it is an issue of pragmatism, You have to look at the states. You have to get buy-in, because obviously this is an international issue. And in order to be effective, you are going to have to get buy-in from a substantial number of states to go along with the process. You know, one of the issues when the legislative guide was being developed, there was a carve-out for financial contracts. And the reason that came about is the IMF and other organizations brought in very substantial expert testimony and studies that unless this was adopted, there'd be systemic crisis. And so part of the issue that UNCTAD needs to look at in regard, and I'm not defending that at this point, but I'm just going through a historical perspective. But, one issue that needs to be looked at very carefully is that as this process is discussed at UNCTAD, there needs to be a pragmatic, basic economic and social purpose of why this is important, because there has to be buy-in as part of this whole process. It has to be well understood, because unless you have the support of all the states as part of this process, you can develop anything you want to, it's not going to work. And one thing that I believe UNCTAD has been very good about is looking at pragmatics, saying, if we're going to work on this and we're going to develop this project, we want something that's going to be accepted and it's going to work and it's going to help the international community. So I think those factors are important.
In the back there? Just why do you believe that it's harder for territories to come to a compromise for the purpose of creating this international insolvency system than it was for the territories to come together and create the CISG, for example?
Well, because the CISG is innocuous.
and it's opt-outable. And I would actually say, and it only relates to private rights, right? I mean, the CISG governs contracts, bilateral contracts, right? It doesn't affect the rights of any third parties, and it's entirely in the private law regime where we permit, contracting around whatever the default rule is, and insolvency has much broader impact in a whole area of, again, public law rights and third-party rights that those contracts just don't have.
And if I could inject a little history here, that is, there were early drafts of similar sort of conventions at the latter part of the 19th century. UNIDROIT's first draft was 1939. The Hague Conference had something in the 60s, and UNCTAD rewrote it in the 80s. So I don't know that I would call it easy.
Just in response to what Chris said, I think two observations. One is times change, and even with the financial contracts part of the legislative guide, times have changed. When did we finalise that? 2004. So 9 years later, maybe it's not fit for purpose. And I think what I'm seeing is, and maybe this goes, to the heart of what it is that we're doing, is everything's speeded up. So back in the 90s, you could spend 4 years, negotiate a model law, you put it on the shelf, you thought you'd done the job. Now, what we develop seems to be a preliminary for the next thing. So we do part 3 of the legislative guide deals with enterprise groups, but it's really an introduction to what comes next. So the whole process is one that's moving away from kind of monolithic texts that will serve the test of time. I think we have to, which makes it really difficult for national legislators, because we're keeping on moving on, and they're still trying to digest what we did in 1997. Let's face it, the model law has, whatever it is, 21 countries adopting it today. Hopefully by the end of the year there might be something in the 40s, but we've moved on, well on to, phase 3, phase 4, whatever. So I don't know what that says about what we need to be doing. I don't think we necessarily need to stop doing what we're doing, but it does kind of change the nature of the game, I think.
I think in the interest of keeping on Ted's schedule, we will break now for lunch, and please join me in thanking again the panelists this evening.